Probation is a method used by the criminal justice system to reform offenders instead of sending them to prison. The main idea is that not every person who commits a crime is a dangerous criminal. Some people commit offenses because of immaturity, poverty, family problems, or lack of guidance. Such people can become responsible citizens if they are given a chance to improve under supervision. What is probation? Probation is a system in which the court allows a convicted person to remain in society instead of sending him or her to jail. However, the person must follow certain conditions fixed by the court, such as maintaining good behavior, meeting a probation officer regularly, not committing another offense, and sometimes doing community service or attending counseling. If the offender obeys these conditions, he or she can avoid imprisonment. If the conditions are violated, the court may cancel probation and send the offender to prison. Thus, probation is based on the principle of reformation instead of punishment. What is parole? Parole is the temporary or conditional release of a prisoner after he or she has already spent a part of the prison sentence. The prisoner is released before the completion of the full sentence because of good behavior or other valid reasons. The person remains under supervision and must follow certain conditions. If these conditions are violated, the person can be sent back to prison to complete the remaining sentence. Difference between probation and parole basis. Probation, parole stage granted before imprisonment. Granted after serving part of the prison sentence given by court. Parole board or government authority, depending on the law. Jail offender usually does not go to jail. Offender has already spent time in jail. Purpose to avoid imprisonment and reform the offender. To help the prisoner return gradually to society, violation probation may be cancelled and imprisonment may follow. Parole may be cancelled and the prisoner returns to jail. Types of offenders for whom I would recommend probation. Probation should be recommended only when there is a reasonable chance that the offender can reform. It is generally suitable for the following categories. 1. First-time offenders. A person who has committed an offense for the first time and has no criminal history should be given an opportunity to improve. 2. Young offenders. Young people often commit mistakes because of immaturity or bad company. Proper guidance can help them become responsible citizens. 3. Offenders convicted of minor offenses. Persons involved in less serious crimes such as petty theft, simple hurt, or minor property offenses may benefit from probation. 4. Offenders who show genuine regret. If the offender accepts the mistake, apologizes, and shows willingness to reform, probation may be appropriate. 5. Persons with stable family and employment. Those having family support, education, or a regular job are more likely to follow the conditions of probation and lead a lawful life. Offenders who should normally not get probation. Probation should generally not be granted to habitual criminals, repeat offenders, persons convicted of serious violent crimes, terrorism, rape, murder, organized crime, or offenses that seriously threaten public safety. In such cases, imprisonment is necessary to protect society. Case study. One well-known example is the case of Ratan Lal v. State of Punjab, 1965. In this case, the Supreme Court of India held that the law relating to probation is beneficial because its purpose is to reform offenders rather than punish them unnecessarily. The court recognized that when a person has committed a less serious offense and there is a good possibility of improvement, the benefit of probation should be considered. Conclusion: probation is an important reformative measure in criminal law. It helps deserving offenders improve while protecting society through supervision and conditions.